ninth episode of this series. We're going to be talking about objections and the rules of evidence. But this one is kind of a doozy. It's a lot, and there's a lot to cover. So I made a resource guide. Mine's my choices and emojis for the examples. But I made a resource guide that will help you break them down step by step. I mean, I can't make a 2 hour video, 2 hour plus video covering everything. So I thought I'd provide you with the resources to allow you to learn about it more. Now, when I was making this, was learning myself and still am learning. This process takes a while. The rules of evidence are, again, a doozy to tackle. So I recommend you looking up Winning Objections Mock Trial Guidebook because it helped me a lot in understanding it. Also, it's very digestible. I took some examples from that, and again, I just really think it's a helpful guide to know. Now, before we jump in, I just want to talk about a little briefly what the rules of evidence are and what their purpose to do. Essentially, in the courtroom, it's a system of justice, and we want to make sure that justice is maintained. And in order to do that, there are some things that cannot be brought into trial that on the basis of simply being unfair. And the rules of evidence kind of dictate what is unfair, what is fair, what you cannot do and can do. And unfortunately, life is very complicated, so thus the rules of evidence is very complicated as well. Thankfully, we don't use the federal rules of evidence. We use a simplified version of that, mock trial, high school. So we're going to be learning that way. Now, what is an objection? Well, you may have heard it in a law film where someone slams on the table and yells objection. Yeah, that's pretty much it. I don't recommend slamming on a table necessarily, but you can definitely object with vigor. But how do you object, and what do you need to do to object? Well, usually you just say objection and the name of the objection. So objection, lack of personal knowledge, objection, relevance, objection, hearsay. Then you just have to make sure that you have your basis of your objection. You're ready to explain why you objected. So, for example, let's do a hearsay objection, which we'll talk about at the very end of this video. So objection, hearsay. Then the judge will ask you to explain your objection. Your Honor, under Rule 801, hearsay, explain the rule, is an out-of-court statement being used to prove the truth of the matter asserted. Here, the witness is testifying to what someone else said, Bob said, on a different day outside of this courtroom. Therefore, by talking about what Bob said, whatever the other person's name is violating the rule under 801, and therefore is not admissible in today's case. Obviously, you can make that shorter or more complex depending on what the objection is and what we are going to do. Now, again, this is kind of going to break down what the extra tidbits in here are, so this is for your knowledge later, and these little call outs will be based on these little emojis here. Alright, now, hundreds rule, we're just going to have the scope and purpose of why we have the rules of evidence. Rule 105 will allow you to provide a limiting instruction. You're never going to say, under Rule 105, can I have a limiting instruction? You're just going to say, Your Honor, may I have a limiting instruction to the jury to just take this for the truth, or to take this for for the how the person responded, but yeah, we'll get to it later. Just know that limiting instructions are just asking the judge to do certain things, whether that's to remind the jury of something based on the objection, etc., etc., etc. We'll get to that later. Again, you can read this example. 106 is just a rule of completeness. It's a little sneaky one. Not a lot of people understand this, so it's not really well used, but essentially, if the team is using the exhibit to read only one part of it at a certain time, you can object under Rule 106 and have the witness read the whole document. Again, this is a little bit more tricky, but it could show, effective knowledge of the rules of evidence. Now, 200s are not very important, other than the fact that you can bring up things that have no real dispute. because they're of some mathematical or scientific certainty. So it's not really disputed that 10 times 10 is 100. You can kind of just bring it up without objection. Someone objects under this, you can, call their attention to Rule 201. But that's pretty much it. Now, for hundreds, we're going to get into a little bit more specific things that are important. So, 401 is relevant evidence. And essentially, you just need to know that evidence is relevant if it has any tendency to make a fact of consequence more or less likely. Fact of consequence really just being something related to the case. This will help you break it down further, but just think about it simply. Does this have any bearing in today's case? If it's about Bob's dog's fur color and Bob's dog is not related to this case at all, well, obviously it's not relevant evidence. So just keep that in mind. Be careful though. Sometimes, they will be establishing a character in the first two questions, and they'll be talking about irrelevant evidence. So just be a little bit careful about that. You may object, and the judge may be like, just move on. 402 is just saying relevant evidence is admissible. So they go hand in hand. If it's relevant, it's admissible by 401 and 402. Read about conditional relevance here and how you would be able to do that in the courtroom. Another little tidbit that you can read about is when something goes to the weight and not the admissibility in your response to someone saying that something's relevant or not relevant. So just look at that when you have the opportunity. Now we are going to head into 403. Now 403 is kind of every beginner in mock trials pitfall. They use it often when it's very difficult to have a successful 403 objection. So that's something you can remember when someone's objecting you about for being used under 403. If someone objects 403 to you, just know that your defense to that is more or less easy. And how you would word that is its probative value is substantially outweighed by a danger of one or more of the following. Okay, and you can go over these, but what you'll see mostly is that its prejudicial value is substantially outweighed by its probative value, meaning that its bearing on the case is much more important than its tendency to unfairly prejudice the jury. Now, again, we have to go through this quickly, but I recommend you look through all these examples and tidbits. Now, let's go to 404. This is talking about character evidence. Now, let's look at just the kind of buzzwords that you need to know for mock trial. 404, character evidence is defined as evidence of a person's character, a character trait. It's not admissible to prove that on a particular occasion that person acted in accordance with that character or character trait. Essentially, you're establishing a character trait to a person. Okay, that's fine. But you cannot use that character trait you associated to that person to prove that they acted in accordance with that character trait on a specific occasion. So if you're just saying that I'm a, reliable kind of person, that's more or less fine. But if reliability is important to that particular crime, you are not able to do that, right? So you're using that character to prove that on the occasion they did not act with that character trait. Again, there are good and bad character traits. I mentioned this too, and a lot of things that we might see with a character trait is not really a character trait. Again, read more about that. I highly recommend. Now, there's exceptions for the defendant in a criminal case. The defendant may offer a trait of the defendant. However, afterward, the prosecution can try to rebut such trait. So there's this idea that once your character has been put under, concern, like someone says that, and you're up against a trial, it's kind of implied that your character is being tested, that you committed some crime, is enough evidence that, they're saying that you're acting in some negative character trait. So the defendant may offer a trait of the defendant, solely the person who's being tried of the crime. But the prosecution can rebut that characteristic trait as well. Okay, so the prosecution can only do that once the defendant the defense tries to bolster their witness. We'll talk about bolstering a little bit later too. Okay, the defendant may offer traits of alleged victim. However, afterwards, prosecution can say no, rebut it, or reverse it on the defendant and say they have the same trait. So let's just say that this is a case of either murder or self-defense. The defendant says, yeah, they were always threatening me. Well, then the prosecution could say, no, they were not, blah, blah, blah. They had a character for kindness and lovability. I don't know, whatever you want to say. Or you can reverse it and say, well, haven't you threatened the defendant before, or haven't you threatened Bobby, who was a victim, in the past before as well? So just keep that in mind. Now, this is just going to point us to some further exceptions for character evidence, which will be in here as well, but under 607, 608, and 609. Okay, other crimes or other acts. Can't use past crimes to show propensity or the tendency to act the same for the same crime. However, you can use those acts to show motive, opportunity, intent, preparation or plan, knowledge, identity, or absence, or mistake, or lack of accident. Again, look through these examples a little bit more clearly. They will be all that you ever hoped and dreamed of. Okay, let's go to 405. Methods of proving character. Okay, so this one is a doozy. This is only going to apply when you're dealing with admissible character evidence. That is, you are establishing a certain trait and are using it to show propensity. Okay? These are admissible character evidence. No, there might be cases where it's not character evidence, but if it is character evidence, you are establishing a trait and you are using it to show propensity. There still are a few times where you can do this. We'll see this also supported by opening the door in 608. This is bolstering. Basically, when the credibility has been attacked, the other party can try to reestablish the good character of that person. When it's an essential element of the crime, again, just there's only certain cases for this. This is a very specific objection. But basically, is when the trait is intertwined with other elements of the charge that it needs to be mentioned. This only applies, however, to very specific cases. So defamation, libel, slander cases, parental fit, custody, negligent hiring or entrustment, etc. You also can use character evidence when it goes to the truthfulness or of the witness. That will also be used in impeachment proceedings as well. Sexual offense cases are also on the books for that as well. Now, even if you have a character trait that fits one of these descriptions, there's another condition that you have to meet. You can only prove them in certain ways, so proving reputation or specific instances of conduct. Again, I recommend you looking at that again. Now, there's another exception if this is a character or routine, habit, routine, or practice that is often observed. So let's just say it was cleanliness. There is a way that the restaurant is cleaned every single day. That's a routine and habit established by the owner of the owner of the restaurant. That would be an example of a habit routine that you could use in the courtroom. Now, subsequent remedial measures, I'm going to skip over. Again, you can read about it. They're not extremely important. I'm going to skip over 409 as well. 411, 501, don't need to worry about. Let's go to 601. General rule of competency. Again, not really important either, but it's a rule that says every person is competent to be a witness. Congratulations, you can be a witness, everyone. That might be good news for a lot of people on your mock trial team. So, hooray. Okay, now let's go to 602. Again, this is where we're getting a little too more of the specifics. This is a lack of personal knowledge / lack of foundation question. So, basically, there's two different sorts. Where you might need to do this. Lack of personal knowledge is basically just saying about something they were not there for. You know, when the witness is saying something that they wouldn't actually know, is it in their affidavit? They're talking about something they did not perceive. they had impaired perceptions, like, they were intoxicated, or they couldn't see well, or they were pepper sprayed, or something like that. So again, there's a weight and a not admissibility exception there, so you can look into that. 607, don't really worry about. Now, we talked about 608 a little bit. Characters for untruthfulness or untruthfulness. So what is bolstering? It's essentially you can't bolster a witness's good character until they have been attacked. So essentially, if you're able to talk about someone's good characteristics as long as they have been attacked for that certain character. We talked about this a little in the past with others. Again, a lot of them are intertwined. A lot of them kind of have to do with the similar themes, but they are, all over the place. Hooray! That makes our life so much easier, doesn't it? Okay, 609 is also very important. It talks about when you can use evidence of a criminal conviction to a witness's reliability. So, for a crime that was punishable by death or imprisonment for more than 1 year, or if the crime shows dishonesty in some way. Again, there is an exception. All this has to follow 403. It can't be more prejudicial than probative. And this is extremely mentioned for 609B when they're talking about the 10 years. If it's been over 10 years, there's an even extra specification here. So, again, just adding on to the issue. Now, there's some other things that I urge you to read through, not extremely important. Just know that 609 is specific to a previous criminal conviction. That's touched on other parts, which we talked about past actions, but this is for criminal convictions, so a little bit different. Now, 610 is a little unnecessary, 611 a little unnecessary. These are more of just objections that you will do without calling out to a specific rule. So if you ever get a case of badgering the witness, again, use that sparingly. The scope of a cross-examination or a leading question, you're not going to say objection rule 611. You're going to say objection badgering the witness, or objection leading question, or objection scope of the cross-examination, which you can read that a little more on too. Now, these are just things that you can do. Fun fact, you can refresh a witness's memory if they're not remembering something correctly. And impeachment is kind of a more proper way of doing this. We will talk about that in the last episode. But essentially, if a witness contradicts their affidavit on the stand, you can bring their affidavit up to them and talk about what the contradicting statement was. Essentially, it's really good for your case. It makes them look like they've been lying. So overall, when you impeach a witness, they look not so great, and you look great. Okay, Rule 701, opinion testimony of a lay witness. This is basically your speculation objection. So A is going to be based on your rational base perception. So this is when we talk about they cannot peer into someone else's mind. So if witness goes up there and they're like, yeah, oops, sorry about that. If a witness goes up there and they say, yeah, Bob was definitely feeling this way or thinking this way, well, they don't know that. They cannot peer into their mind. If they saw Bob was shaking and sweating, that's a different case because that's rationally based on the witness's perception. So you can be ready to defend that objection if there was a rational basis for what the witness is saying. We also see where they're giving an expert testimony about something they're not an expert of. So just make sure that they are doing that correctly. Now, with testimony by experts, they need to qualify, or they need to mention a few things by 702. One, they need to talk about their education and specialties. And two, B, they need to talk about their materials they relied on to come to their conclusion. Okay, so that's a way you can kind of catch people. And in order to prove expert testimonies or, testify as an expert, you need to prove both of those things or talk about both of those things. Okay, basis of expert opinion and testimony. Again, we have reverse 403 in here. Urge you to read about it. Again, less common. Opinion on the ultimate issue. Essentially, this one's a little vague. It says not necessarily objectionable if it embraces an ultimate issue. Really, this can just lead to some challenges. You can argue this when a witness is telling the jury what conclusion they should be should come to, that is not admissible. Not necessarily in the rules, but you should argue that this is something the trier of the fact, the jury, should come to. And the witness should provide the means for them to reach that conclusion, but not explicitly direct them to. But as if you're getting this objection by someone else, you can say, under Rule 704, opinion on an ultimate issue, it is not necessarily objectionable if witness testimony embraces an ultimate issue. Okay, there's a subpart to that in B. Urge you to look it out for it. Okay, 705, disclosing the facts or data underlining an expert's opinion. Again, this is not very important. Again, you can use it rarely. You can look at my don't recommend doing this, yippee. But other than that, let's get to the more important one, probably what you've heard all your life, hearsay, if you've heard any objections before. So there's a few definitions that we need to establish before jumping into hearsay. The first is a statement. So a statement can be oral, obviously, a written statement, or a nonverbal assertion. So like someone pointing or someone nodding. That's a nonverbal assertion that still counts as a statement. Now, declare is the person who made that statement. Note that they may be a person. Wow. They might be surprised. There might be a statement that was maybe AI generated. You could see that in the future. They're not a person. They're a machine that does not have a heart and a brain. Maybe an artificial one, but not a person nonetheless. Now you get to the big daddy definition for hearsay. Hearsay is an out-of-court statement used to prove the truth of the matter asserted. So let's break this down. There's two parts. It's an out-of-court statement. So even if the person who is testifying, if the statement they made is not in court, they cannot say it. Even if it was them. I know it's weird, but it was a statement made that was out of court, and it's being used to prove some truth, then they cannot say it. Now, to prove the truth of the matter asserted is something you will see contested very frequently in mock trial, and to be honest, I think a lot of judges get tired of it. Essentially, you have to be using that statement to prove the truth of the matter asserted. What does that mean? The truth of the statement. So if I was saying, we have Bob and Jill, and Bob told Jill, it is raining outside, okay? And Jill says, Bob told me it was raining outside. Well, and someone objects to hearsay. Well, are you using it to prove that it was raining outside? Or were they using it to prove that's why Jill grabbed her rain jacket? Those are two very different situations. That is effect on the listener, or subsequent actions. And this is how I would respond to the judge. So I'll act as both people. Your Honor, objection, hearsay. May I give my reasoning? Yes, you may. Under Rule 801, hearsay is an out-of-court statement being used to prove the truth of the matter asserted. Here, Jill is testifying to what Bob told her on occasion that was out of court today. Therefore, it constitutes as hearsay under the Rule 801. Now, as the other lawyer, this is how I may respond. Your Honor, may I respond? Hearsay is an out-of-court statement being used to prove the truth of the matter asserted. Here, Jill is testifying to what Bob told her to show the jury the subsequent action she took in putting on a rain jacket, not to show the proof. Or not to show the truth that it was in fact raining outside. Therefore, this evidence is admissible in the courtroom today. So you can use that to your advantage. Again, this is very, very common. Again, example is raining outside. You know what I mean now. Okay. Statements are not hearsay. Now we're going to get to the exceptions. Ooh, woohoo! 1, declarant witness prior statement, so you can impeach someone. That's pretty much what it means. Again, we'll go over impeachment later. 2, opposing party statement was made by the party in an individual or representative capacity. Again, this is a little bit specific to Arizona's 2024 mock trial case. If you want to look at this for reference, there's going to be a lot of references to it throughout this document, so I will attach it to our overall materials in the resource PDF section. If you want to learn with that case, I highly recommend it. But essentially, if you are the defendant, your statements can come out. And if you're a party, agent, or employee for the company, for example, in the case I'm talking about, it was Desert Willow High, and their employee, Terry Swift, was also the defendant. So it was Desert Willow High and Terry Swift. But it also could be an agent of Desert Willow High, like the principal, Jamie Hager. So Jamie Hager's statements could also be allowed. Okay, 802 is kind of like what we've seen in the past with the relevant evidence. 402, hearsay is not admissible unless it is an exception. So I would like to revise a statement that I made earlier. Under 801D, these are just statements that are not hearsay. They do not fit the definition for hearsay. They're not exceptions to hearsay. So make sure when you're doing your therefore statement, you don't say, therefore, this is an exception to hearsay. You say that this is not hearsay, Your Honor, right? Now, the exceptions to hearsay come when we look at, where is it? 803. So, exceptions to the rules against hearsay. The first is presence of impression. Basically just describing an act you're doing. Excited utterance, statement made under intense emotion. It has to be exactly in that moment. You can't just be like, well, their fear over the robbery lasted a month later. No, it has to be during the robbery. They said, oh, I did it, or oh, I helped him, or something like that. Then existing mental, emotional, or physical condition. So it lists the emotion they were feeling or their motive, intent, plan. What are you doing this weekend? I'm going to go kill Bob. Hey, how are you feeling? I'm feeling sad. My leg feels like it's about to fall off. See, those are all examples of then existing mental, emotional, or physical condition. 4, statement made for medical diagnosis, a patient giving a doctor their medical history. Do not use this for the other way around. A doctor giving a patient something. It has to be a patient giving a doctor something. Again, really, really specific, and again, something nitpicky. Again, if you want to be a master of mock trial, you got to know all this stuff, or you don't even need to know all this stuff. There's the ones I've spent the most time on, I would focus on. Okay, recorded recollection, something that is written down to remind the witness. Records of regularly conducted activity, you'll see a lot, especially with exhibits. As I mentioned very beginning, exhibits can be objectionable. For instance, if it was a business document, you need to make sure it meets all of these steps to be an exception of hearsay, because it is hearsay. So make sure that you meet all of those steps, and then the rest you can kind of look for later. They're not very important. Now, hearsay exceptions when the defendant is not there. For example, the defendant died or there's something else that's prohibiting the witness from being there. Again, you can look at the examples of what constitutes for that. There are other exceptions. Statement under belief of imminent death, statement against interest, statement of personal or family history, statement offered against a party that wrongfully caused a declarant's unavailability. There's also 805, hearsay within hearsay. So if you have someone that said, Bob told me that Jill said, go to the mall. Well, you have to make either prove that there's an exception or that it's not hearsay for the layer of saying, Bob told me. Okay, but what that has to be under a hearsay objection, or sorry, a hearsay exception or not hearsay. Bob told me that Jill said. Now you need to have the Jill said part fit an exception or not constitute as hearsay. So there's a lot of like little barriers you have to reach for hearsay within hearsay, and it's fun to argue with, but it's definitely difficult. And then lastly, 807 is kind of your last straw. Hearsay is used to keep out statements that have a character for untruthfulness. So there's not a specific exception for what you need. You can kind of use this as your last cost. I think it would really help you if this piece of evidence came in. You could say, this does not have a character for untruthfulness. Whether that be some sort of like bank records, but you don't have the ability to prove the regularly conducted or regular recorded activity. That's something you could kind of do as a shot in the dark. Again, don't recommend, but it's something that you can do. Anyways, I hope you enjoyed this under 30-minute, wow, 30 minutes, that's crazy, presentation of the rules of evidence. I really suggest that you look through this guide more, maybe purchase a book that I had recommended above. again, mock trial is a continuously learning journey, and I'm excited that you're going on it. Okay, bye bye.